Welcome to the Deep Dive. Today, we're going a little deeper into oil and gas.
Deeper than usual.
Yeah, a little deeper than those headlines you usually see.
Yeah.
We're going to explore something.
Something crucial.
Yeah, that impacts every big project in the industry. Disputes.
And how to resolve them, of course.
Of course. So it's a world of billion-dollar contracts.
Absolutely.
And complex engineering.
Yeah.
And sometimes things just don't go according to plan.
That's putting it mildly.
Right. And when you have millions or even billions on the line,
Yeah.
you don't want things...
Dragging on in court.
Yeah, dragging on in court for years and years. So that's where ADR comes in.
Right. ADR, or alternative dispute resolution.
Okay.
It's kind of like a specialized toolkit for resolving these conflicts.
Okay, I get that part. So it's like an alternative to having those big lawsuits.
Right. Outside those traditional courtrooms.
Okay. But what's actually in this ADR toolbox? What are the tools?
Well, think of it this way. You've got negotiation,
Yeah.
where the party's trying to just hash things out directly. Then there's mediation, where you've got a neutral third party who helps facilitate a conversation.
So they're like a referee.
Yeah, you could say that. Helps facilitate a conversation and hopefully...
To a compromise.
Yeah, reach a compromise. And finally, you've got arbitration,
Okay.
which is more like a private courtroom
Oh, interesting.
with a binding decision.
So instead of battling it out in public court, you're choosing a more controlled setting,
Yeah,
like picking your battleground.
I like that analogy.
Bang.
And in the oil and gas world, that choice of battleground can be absolutely crucial.
I bet.
These projects are often international,
Right.
incredibly complex technical aspects,
Yeah.
and confidentiality is paramount.
Right, because a public lawsuit could really air all sorts of dirty laundry
Exactly.
that a company just does not want out there.
Especially when their reputation's on the line.
Right, exactly. Plus, time is money,
Always
especially in this industry. A delayed project.
millions per day.
Oh, wow.
ADR, particularly arbitration, can often resolve disputes much faster.
So we're talking shaving years off a dispute timeline.
Potentially, yeah.
That's huge.
Ugh.
But how does this arbitration thing actually work?
So, both sides present their case, their evidence. They may even call in expert witnesses.
It's like a mini trial.
You could say that, but instead of a judge, you have an arbitrator.
Okay.
Usually someone with deep expertise in oil and gas.
They know what they're talking about.
Right, they make the final call.
Okay. So I've always wondered, what happens if one side just refuses to participate in arbitration? Can they just ignore it?
That's where those contract clauses we talked about come in.
Oh, yeah, those super long legal paragraphs everyone skips over.
Yeah, exactly. But in oil and gas contracts, those dispute resolution clauses are absolutely critical.
They're like the rule book for how any disagreement is going to be handled.
Precisely. They specify which ADR method will be used,
Okay.
whether it's negotiation, mediation, or arbitration. And they can even stipulate things like where the arbitration will take place,
Okay.
what's called the seat of arbitration.
Wait, the seat, like where they put their chairs.
It sounds a bit strange, I know.
Yeah.
But the seat determines which country's laws will actually govern the arbitration.
Oh, wow.
So let's say you have a dispute between a U.S. company and a company in the Middle East.
Okay.
Choosing London as the seat
Okay.
means the arbitration will be conducted under English law.
So even that seemingly small detail can have huge implications.
Huge.
It's like choosing the referee for the match.
Yes,
And, some referees are stricter than others.
exactly. And if a contract clearly states that disputes will be resolved through arbitration in a specific location,
Okay.
it's much harder for one party to just back out. They've already agreed to it.
It's like setting the ground rules before the game even starts.
Right. But you're right, these contracts are so complex.
Yeah.
How do they ensure that everyone actually tries to find a solution
Right.
before jumping straight into arbitration?
Yeah, because I imagine that can get pretty expensive.
Oh, absolutely.
Yeah.
That's where the idea of a multi-tiered dispute resolution clause comes in.
Okay, multi-tier. Break that down for me.
So imagine this. There's a disagreement over a delay in a pipeline project.
Okay.
Instead of immediately going to arbitration,
Right.
the multi-tiered clause might require them to first try to negotiate directly.
Okay.
If that fails, they move to mediation.
Okay.
And only if mediation doesn't work
Yeah.
do they go to arbitration as a last resort.
So it's like saying, look, before we spend a fortune on lawyers
Yes.
and arbitrators, let's try to talk it out like reasonable people.
Exactly. It encourages a more collaborative approach.
Why?
And it can save everyone a lot of time and money.
Yeah, for sure. Okay, so we've got these basic tools in our ADR toolbox.
We do.
And we know the contract is like the rule book for how to use them.
Right.
But let's get real. What kind of things actually lead to disputes in oil and gas?
Oh, you wouldn't believe some of the stories.
Bet.
But some common scenarios are delays in project completion, cost overruns that just balloon the budget,
Yeah.
and of course those tricky environmental liability issues.
Okay, let's dive into that first one. Delays. I mean, these are massive projects.
Huge.
With tons of moving parts. I imagine delays are pretty common.
You're absolutely right. Think of a project like building an offshore drilling platform.
Okay.
You've got weather disruptions, equipment malfunctions, even political instability in the region.
Wow.
Any of those things can throw a wrench into the timeline.
For sure. So let's say a hurricane hits and delays construction by months.
Right.
How would ADR come into play there?
Well, first they'd look back at the contract.
Okay.
Does it have what's called a force majeure clause
Okay.
that covers events like natural disasters?
Okay.
If so, that could excuse some of the delay. But then the question becomes, is one party actually responsible for mitigating the damage and getting things back on track?
Ah, so even if the hurricane isn't anyone's fault, there might still be disagreements
Exactly.
about who has to clean up the mess and how long they get to do it.
Exactly. And that's where ADR can help determine those responsibilities
Okay.
and maybe even renegotiate the project timeline or costs.
It's about finding a solution to get things moving again.
A practical solution.
Right. This is making sense. What about those cost overruns you mentioned?
Oh, boy.
I feel like that's a recipe for some finger-pointing and arguments.
Oh, they definitely can be. Imagine a pipeline project where the cost of steel suddenly skyrockets.
Okay.
The contractor might say, look, I can't build this pipeline at the original price.
And the company that hired them is probably saying, wait a minute, we had a fixed contract? You can't just change the rules now.
Right. So now you have a dispute.
Uh-huh.
And depending on how the contract is worded, ADR could be used to determine if that price increase is justifiable,
Okay.
if the contract needs to be renegotiated,
Right.
or if one party is liable for absorbing those extra costs.
So it's not just about who's right or wrong. It's about finding a way to manage these unexpected situations.
Yes.
And keep the project from falling apart.
Precisely. And it's often much more efficient to do that through ADR than by going to court,
Yeah.
where things can just drag on for years and legal fees can eat into everyone's profits.
Makes sense.
Yeah.
Okay, we've covered delays, cost overruns. Let's talk about that third one you mentioned. Environmental liability.
Ooh, that's a big one.
That seems like it could get really messy.
It absolutely can. Oil and gas operations, just by their nature, have the potential to impact the environment. Spills, leaks, habitat disruption, the list goes on.
So let's say there is an oil spill. Who's responsible for cleaning it up? Who pays for the environmental damage? These are tough questions.
They are, and those are exactly the kinds of questions that ADR can help answer.
So we might have a situation where multiple companies are involved
Yes.
in a project and a spill happens. ADR could help determine who's liable, who has to pay,
Yeah.
and maybe even how to prevent something like that from happening again.
Exactly. And these cases often involve complex scientific evidence. You might need marine biologists to assess the impact on wildlife,
Oh, wow.
geologists to study soil contamination.
So it's not just lawyers arguing legal points. It's bringing in that scientific knowledge
Yes.
to make informed decisions.
Exactly. About responsibility and remediation.
You got it. And that's one of the strengths of ADR.
Absolutely.
It can accommodate that level of technical complexity and bring all the necessary expertise to the table.
Yes.
This has been incredibly insightful. We've covered a lot of ground, from the basic tools of ADR to how it plays out in real-world disputes. But I have a feeling this is just the tip of the iceberg.
You're right. There's a whole other layer to this, how technology, globalization, and those ever-changing regulations are shaping the future of ADR in oil and gas.
Welcome back to the deep dive. In part one, we really dug into the basics of ADR in oil and gas.
All those tools and strategies for resolving disputes outside those traditional courtrooms.
Right. And we even got into some of the real-world scenarios,
Oh, yeah.
those project delays and cost overruns and that whole messy world of environmental liability.
Absolutely.
And now,
it's time to look ahead.
yeah, it's time to turn our attention to the future.
To the future, because the world of ADR isn't static.
Right.
It's constantly evolving.
Yeah, and it's being shaped by some pretty powerful forces like technology,
Yes.
globalization, and a constantly evolving regulatory landscape.
Right.
Okay, so let's talk tech first.
Yeah.
I can already imagine how technology is streamlining things,
Oh, absolutely.
making communication easier,
Yeah.
and maybe even changing the way these dispute resolution processes actually happen.
You're spot on. We're seeing a rise in virtual hearings, for example.
At virtual hearings.
Yeah, where parties and arbitrators can participate remotely
Oh, wow.
using video conferencing.
So no more expensive flights.
Exactly.
And hotel stays just to sit in a room and argue.
You got it.
Yeah.
Imagine a dispute involving a pipeline project in Africa,
Okay.
with experts and lawyers joining the hearing from offices all over the world.
That's amazing. So technology is making it more efficient and accessible.
Yeah, especially for smaller companies.
Right.
Or those located in more remote regions.
Okay, virtual hearings, that makes sense. What other tech innovations are we seeing?
Well, think about all those documents involved in a typical oil and gas dispute.
Oh, yeah.
Contracts, technical reports, emails.
It's a mountain of paperwork.
It can be,
Yeah.
and that's where electronic document management comes in.
Okay, so it's all going digital.
Exactly.
Right.
We're seeing more and more cases managed digitally,
That makes sense.
making it much easier to share and access information. Not only does this speed up the process, but it's also a lot more environmentally friendly.
Yeah, no more printing out those stacks and stacks of paper.
Exactly.
So technology is making ADR more efficient, more accessible, and even greener.
That's right.
What's not to like? But are we seeing any really cutting-edge technologies being used?
Like what?
Like artificial intelligence?
We are starting to see AI play a role, particularly in analyzing those massive amounts of data
Okay.
that are often involved in these disputes. Imagine a case involving a complex offshore drilling operation.
Okay, I'm picturing tons of sensor data.
Yeah.
Geological surveys, engineering reports,
Exactly.
all that stuff.
Expert systems powered by AI can sift through all that data,
Wow.
identify patterns,
Ah.
and highlight potential inconsistencies.
Okay.
That might be relevant to the dispute. It's like having a super-powered research assistant.
That's incredible. And it could really level the playing field.
Yeah.
Especially for smaller companies
Right.
who might not have the resources to hire all those analysts.
Exactly. It can make the whole process more equitable
Right.
and more transparent.
Okay, so we've covered the tech side of things.
We have.
Let's shift gears and talk about globalization. I know the oil and gas industry is inherently global,
It is.
but how is that impacting the way these disputes are resolved?
Globalization is leading to more cross-border projects,
Okay.
joint ventures involving companies from different countries,
Yeah.
and increasingly complex contracts.
Right.
All of this inevitably leads to a rise in international disputes.
And I imagine those disputes can get pretty tricky to navigate.
Oh, they can. Different countries have different legal systems,
Of course.
different cultural norms, even different ideas of what's considered fair or ethical.
Right, exactly. And that's where international arbitration comes in.
Yeah.
It's like a neutral forum
Uh-huh.
for resolving these disputes that involve parties from different countries.
Exactly.
So instead of getting bogged down in all the complexities of multiple legal systems,
Right?
you can agree to have the dispute heard by a neutral panel of arbitrators,
Yes.
applying a set of internationally recognized rules.
Precisely. Institutions like the International Chamber of Commerce
Okay.
or the London Court of International Arbitration,
Uh-huh.
they provide those established frameworks.
So it's almost like a common language
It is.
for resolving disputes
It's on a global scale.
on a global scale.
Yeah.
Okay, that makes sense. But what about those cultural differences we talked about?
Right.
How do you make sure that everyone feels like they're getting a fair hearing
Yeah.
when they come from such different backgrounds?
That's where cultural sensitivity becomes so crucial.
Okay.
Mediators and arbitrators need to be aware of those differences
In what way?
in communication styles,
Okay.
negotiation approaches,
Ah.
even how different cultures perceive concepts like time
Oh, wow.
or authority.
So a mediator who's used to very straightforward, direct communication
Yeah.
might need to adjust their approach when working with parties from a culture where indirectness and saving face are more highly valued.
Exactly. And the arbitrators need to be sensitive to those nuances as well,
Right.
making sure everyone feels heard and respected, even if they're not expressing themselves in the same way. It's about bridging those cultural gaps
Right.
to ensure a fair and impartial process.
It sounds like being a successful mediator or arbitrator in oil and gas.
It's tough.
It takes a lot more than just legal expertise.
Absolutely.
It takes a deep understanding of different cultures and business practices. It's almost like being a diplomat.
You could say that.
Okay, we've talked tech, we've talked globalization.
Mhm.
Now let's tackle that third big force shaping ADR regulations. I know the oil and gas industry is heavily regulated.
Very heavily regulated.
And I imagine how changes in those regulations can lead to all sorts of disagreements.
You're absolutely right. Regulations are constantly evolving,
Yeah,
especially when it comes to things like environmental protection, safety standards,
of course.
resource management. And those changes can create uncertainty
Right.
and lead to disputes when different parties interpret the rules differently.
So let's say a new regulation is introduced to limit methane emissions from oil and gas operations.
Okay.
One company might argue that they're already in compliance,
Right.
while another might say the rule is too vague or that the technology to comply doesn't even exist.
That's a great example. And that's where ADR can provide a mechanism
Okay.
for resolving those disputes outside of court.
Where things can get very expensive.
And time-consuming.
Exactly. I can see how ADR would be particularly useful in those situations where there's a lot of technical complexity.
Yeah.
You might need engineers,
Absolutely.
environmental scientists,
Yeah.
other experts to really weigh in
Right.
and help the arbitrators understand the issue.
Exactly. Take the example of a dispute over the environmental impact of a proposed pipeline project.
Okay.
You might have biologists presenting evidence about potential harm to endangered species.
Oh.
Hydrologists studying the effects on water resources.
So again, it's not just about the lawyers arguing legal points.
Right.
It's about bringing in that scientific knowledge
The science.
to make informed decisions
Yes.
about whether a project can proceed or what measures need to be taken to mitigate any potential harm.
You've hit the nail on the head. ADR allows for that integration of scientific expertise,
Right.
which is often essential in disputes related to environmental regulations or safety standards.
This is all fascinating stuff. It seems like the future of ADR in oil and gas is all about adapting to change,
It is.
embracing those new technologies, and navigating a world that's increasingly interconnected and complex.
It is. That's a great summary. But there's one more trend we should touch on before we wrap up this part.
Okay.
The rise of expert determination in certain types of disputes.
Okay, expert determination.
Yeah.
That's a new one. How does that work?
Imagine you have a dispute over the valuation of an oil field
Okay.
that's being sold as part of a merger.
Okay.
Instead of having a full-blown arbitration,
Wait.
the parties might agree to appoint a neutral expert,
No.
someone with deep knowledge of oil and gas reserves, to determine that fair market value.
So instead of a panel of arbitrators, you have a single expert
A single expert
who makes a binding decision.
based on their technical assessment.
Okay. So it's a more streamlined and often more cost-effective approach
Right.
for resolving those disputes that hinge on very specific technical questions.
Precisely. And we're seeing expert determination used more and more in oil and gas, particularly in disputes related to valuation, technical specifications, or the interpretation of complex data.
This has been incredibly insightful. We've covered a lot of ground.
We have.
Virtual hearings, the role of AI, the complexities of international disputes.
It's a lot.
We've explored how technology is making ADR more efficient,
Yes.
more accessible, how globalization is driving the need for that cultural sensitivity,
Absolutely.
and how those evolving regulations are creating new challenges
For sure.
for dispute resolution. But I have a feeling we're not done yet. There's still that question of what this all means for the people
Right.
who are actually involved in negotiating these contracts and
Yeah.
navigating the world of ADR.
You're right. In our final part, we're going to get practical and provide some tips and best practices for anyone involved in oil and gas contracts and ADR.
Welcome back to the deep dive. We've made it to the final part of our journey through the world of ADR and oil and gas.
We've explored how disputes arise, the tools for resolving them,
Right.
and those forces that are shaping the future of this field.
And now for our final act, we're going to shift gears.
From big picture trends
From big picture trends to some practical advice.
to practical advice, think of it as your survival guide for navigating oil and gas contracts.
And the world of ADR.
Yes, because knowledge is power, especially when you have millions or even billions of dollars at stake.
Okay, so let's get down to brass tacks.
Yeah.
If you're someone involved in oil and gas contracts, what's the single most important piece of advice you'd give them?
Don't skim those dispute resolution clauses.
Oh, yeah, I know what you're talking about.
Those dense legal paragraphs
Yeah.
full of legal jargon, but they are absolutely critical.
Right.
Those clauses are the bedrock of how any disagreement is going to be handled.
It's like making sure you understand the rules of the game before you step onto the field.
Exactly. Those clauses specify which ADR methods will be used, whether it's negotiation, mediation, or arbitration. They might even outline what's called a multi-tiered approach,
Mm-hmm.
where you try to resolve things amicably before resorting to those more formal procedure.
Right, we talked about that. It's
Yeah.
like saying, hey, before we bring in the lawyers and the arbitrators,
Yes,
let's at least try to work this out ourselves.
exactly.
But let's be honest, even with the best intentions, disputes happen.
They do.
So what should someone do if they find themselves in that situation?
Half things first, review that contract like your business depends on it.
Because it probably does.
It probably does. Pay close attention to those dispute resolution clauses.
Okay.
What did you agree to? What steps are actually outlined?
So you're not just refreshing your memory, you're also looking for leverage,
Yes,
seeing what options and rights you have under that contract.
exactly. And while you're at it, start gathering all the relevant documentation you can find.
Okay.
Emails, meeting minutes, technical reports.
Anything that supports your side?
Anything that supports your side of the story. It's like building your arsenal before heading into battle.
But I imagine it's also important to try to understand the other side's perspective.
It is, absolutely. Try to put yourself in their shoes.
Okay.
What are their concerns? What are they hoping to achieve? You might discover there's more common ground than you initially thought.
That makes sense.
Yeah.
Finding a win-win solution is always better than a long, protracted fight. But what if the other side is just being unreasonable?
Right.
What if they refuse to even engage in the ADR process that's outlined in the contract?
That's where you have to politely but firmly remind them of their contractual obligations.
Okay.
Point to those dispute resolution clauses
Mm-hmm.
and reiterate the benefits of ADR, speed, confidentiality, the ability to choose experts who understand the intricacies of the industry.
So it's like saying, look, we both signed this agreement. Let's stick to the plan.
Exactly. And if they're still digging in their heels,
Yeah.
well, then it might be time to seek legal advice.
Okay, so we've talked about the legal and procedural side of things. But what about that human element?
Right.
Any tips for just communicating effectively during ADR?
Communication is key. Remember, even in a dispute, you're still trying to find a solution that works for everyone.
Right.
Be clear, be concise, but also be respectful. Listen actively to the other side's concerns. You might learn something that helps you find that common ground.
So it's about keeping that dialogue open,
Yes.
avoiding those emotional escalations that can derail the whole process.
Exactly. And if you're heading into mediation or arbitration, assemble a strong team,
Okay.
experienced lawyers
Mhm.
who know the ins and outs of ADR and oil and gas, technical experts who can provide those crucial insights,
Right.
anyone who can contribute to building a strong case.
So it's not just about showing up. It's about showing up prepared with the right people and the right mindset.
Precisely. And one final thought, be realistic about your expectations.
Okay.
ADR is often about finding a compromise,
Right.
a middle ground that everyone can live with.
It's not about winning at all costs.
No.
It's about finding a solution that allows everyone to move forward
Yes.
and hopefully salvage those valuable business relationships.
Couldn't have said it better myself.
This deep dive into ADR and oil and gas has been incredibly insightful.
We've covered a lot of ground,
Oh, yeah.
exploring how disputes arise, the tools for resolving them,
Right?
and those forces that are shaping the future of this field.
So as we wrap up, what's that key takeaway you want our listeners to remember?
Remember that knowledge is power. Understanding ADR, having a solid dispute resolution strategy,
Mm-hmm.
and approaching these situations with a mix of pragmatism and preparedness can make all the difference.
It's about protecting your interests, preserving those relationships,
Yes.
and ultimately keeping those oil and gas projects flowing smoothly.
Well said. And now for a final thought to ponder. How do you think the rise of renewable energy will impact the future of ADR in oil and gas?
That's an excellent question to leave our listeners with. As the energy landscape continues to evolve, so too will the way we navigate disagreements and find solutions. Thanks for joining us on this deep dive into the world of oil and gas disputes.